Welcome to the Grow Your Law Firm podcast, brought to you by Pilma. This podcast helps lead lawyers to more growth, profit, and freedom. Here is your legal marketing expert and host, Ken Hardison.
Hello, everyone. This is Ken Hardison, and welcome to another episode of Grow Your Law Firm. And today we had the pleasure of having Jason Lazarus, who is a lawyer and the founder and chief executive officer of Synergy Settlement Services, and also the author of a book called The Art of Settlement. And Synergy allows trial lawyers to focus on what they do best. And so what he does, he deals with the issues such as lien resolution, Medicare compliance, public benefit preservation, settlement planning techniques for protecting the recovery, which is something that you as PI lawyers out there need really be thinking about. He's also principal and president of Multi-Claimant Solutions, which offers lien resolution and MSP compliance services for mass torts. So if you do a lot of mass torts, you're staying busy because that business is just rocking and rolling these days. But he is the renowned legal expert. I've heard him on another podcast and wanted to get him on mine. He resides down in Florida, in Orlando, and he's the proud father of 3 children, Sarah, Kyle, and Camille. And he's also an avid cyclist and amateur auto racing. So you like to go fast. I love it. I love it. So anyway, and so let's just get right down to it. So when somebody, we were talking before this started, and back when I was practicing law, we did a lot of workers' comp in North Carolina. Back then, I don't even know what it is now. Back then, if you settled a case for at least $250,000, you had to have a Medicare set aside, or don't. You could be in big trouble. I mean, you could expose your client, expose yourself too. But not so with PI cases. So my question to you is, what is the ethical responsibilities of lawyers, and what are the kind of malpractice traps that probably lawyers haven't even thought about? Because I've always said, one of my mentors says, you don't know what you don't know, right?
Yeah, absolutely. I mean, unfortunately, this area, unless you are studying it daily, you're going to be behind the curve, because there's so many issues between lien resolution, government benefits, Medicare compliance, which you're talking about, and settlement planning related issues. All of those are separate and distinct areas that have fertile ground for making a mistake that could lead to malpractice, or worse yet, having the government scrutinizing what you're doing. And in the Medicare conditional payment world, for example, the government has gotten the DOJ involved in instances where law firms didn't protect Medicare's conditional payment reimbursement rights, and enforcing requirements on law firms to have Medicare compliance programs within their law firms. That's just one example of many. Medicare Advantage plans, for example, are plans that are privately run but pay out Medicare dollars, and they have the same recovery rights as Medicare. They've gotten aggressive with their recovery rights and have been suing law firms for double the lien amount under the double damages provision in the MSP. So those are 2 quick examples of areas that are really specialized. And if you don't know what you're doing, unfortunately, you can make a mistake. So, I mean, the ethical duties and responsibilities and the malpractice risks are many. And the bottom line of it is really law firms have to have a program within their firm or outsource to make sure that they're not making mistakes that could either cost them a lot of money or cost their clients a lot of money, or maybe even worse yet, both.
Another thing, when I used to settle workers' comp cases, and I found that sometimes these lawyers, I found mistakes. I also did SSD law, and if they didn't do a certain type of agreement when they did their agreement, where it laid it out in front of, like, spread it out over future years. In fact, it's been so long, I don't remember what they call it. I'm sure you know. What do they call it? I know you know what I'm talking about. So that so that they wouldn't be earning too much money or whatever, especially if they were on Medicaid. But anyway, does I guess my question is, does any of these things apply to PI settlements? Because my understanding in talking to you before we started today, there is no formal rules out there. I mean, there's no guidance really per se, is there?
Yeah, not with Medicare set asides. So that definitely is a gray area. Although, the Medicare has made it pretty clear that they expect the trust fund to be protected, whether it's a liability or work comp settlement. They just have not issued formal guidance as to how to best do that. The problem is now you've got a mandatory reporting requirement for insurers. So anytime they settle with a Medicare beneficiary for $750 gross settlement or more, which practically speaking is every settlement, they got to report that information to Medicare, and it's a data dump. It's all the ICD codes. It's all kinds of biographical information, which gives Medicare this incredible database to determine if people are using Medicare for injury related care when they've gotten a recovery. And in that instance, that's where the risk is that Medicare could deny care. That risk is low, but the problem is if it happens, the lawyer then is going to have the client back on their doorstep. The Medicaid stuff is pretty cut and dry. That is, needs based. If you give the client too much money, you're going to kick them off benefits. You got to make sure that if they're on Medicaid or SSI, those are the two primary needs-based benefits, that those are protected. And the problem is, even lawyers confuse all of these government benefits. They sound the same. They're all administered by the same agencies. It's confusing as hell.
Yeah, because you got Medicaid, you got Medicare set aside, you got Medicare Advantage plans, you got Medicare conditional payments, and then you've got ARISA liens and dealing with the doctor's liens. I mean, and I'm not saying that every case needs it, but I mean, if you settle a case for $1 million, $2 million, I would think I would be worried because there's a lot of money there and you made a big fee, and sometimes the government, they don't feel too sorry for you when you make a real big fee. I mean, they don't really have a lot of sympathy for you. Yeah, I don't think what you found, but
No, that's it. I mean, in these actions where Medicare has, sicked the DOJ on law firms, that basically they've just said, hey, lawyers have the responsibility to protect Medicare. So you better be mindful of that. And, if you don't have a program in place, they're going to tell you that you need to have one in place when they come after your firm. And so, I really liken this to what insurers have done for a long time, which is it's a lot of big CYA. I mean, you see it today with settlements involving Medicare beneficiaries. Insurers have these protocols and processes, and they drive settlement docs with, frankly, inappropriate language, but that's another topic for another day. But law firms are not equipped and don't do what they probably should be doing these days, which is either have a compliance department in their law firm or hire a firm like Synergy to do it, because one way or the other, at some point, these issues are going to arise. And I talked with a law firm in Maryland that was the subject of one of these DOJ actions, and they were telling me about what led to it, and it was just a simple, innocent mistake. But the problem is that they didn't really know the process to get this dealt with, and frankly, that led to them putting their E&O carrier on notice and having to pay out money, which nobody wants to be in that boat.
yeah. And the thing about it is, I don't know this, but I should ask you before we started today, but most lawyers, don't they pass this cost? I mean, whatever your cost is, to pass it along to the client, take it out of the proceeds. So it really is kind of a no-brainer, I would think. I mean, that's what I see in the mass tort world anyway, because I mean, I've done some in associated lawyers, and I see that, have to pay those some of them weight, I guess, and charge bigger fees.
Yeah, most states allow the expense to be passed along to the client as a client cost. In the lien resolution space, the way we do it is we do it on a percentage of savings, and we don't get paid unless there's a reduction. So we're kind of in the same boat like the lawyer is with the recovery, and ultimately that typically drives a better result in the end for the client anyway, because all of our folks are incentivized and being pushed to get the greatest possible reduction of that lien, because obviously that's for the betterment of the client, and it's how we also at the same time are profitable. So although really we're so focused on this mission of making sure that we are bettering the lives of those that we get the opportunity and privilege to help. So that is a huge focus, and we do that by putting more dollars into their pocket, or protecting the recovery, depending on what we're doing. If we're resolving liens, obviously we're putting a lot more money into their pocket usually than what the trial lawyer could get, just because we do this on a daily basis, whether it's Medicare, Medicaid, ARISA, hospital liens, FEBA, military, what have you. All those are things that we do every day, day in, day out. So we've got that expertise and knowledge to get the best possible reduction.
So I'm going to show a little bit of my ignorance here. I'm going to be very vulnerable. That's what Renee Brown says to be, show your vulnerability. So I'm going to do that today.
Yeah.
I haven't practiced in, I guess, a little over 10 years actively. And I remember when I was practicing, used to be, you could send this ARISA letter, and if they don't comply with it or whatever, you could, and ask them for the plan and all these certain things, you could, my question is, but I've also heard there's a U.S. Supreme Court case out that maybe came out since I practiced. I'm not sure. So can you kind of fill our listeners in on that? Because, can you still, have they got a lock on it, or is there still ways to deal with ARISA liens?
Well, unfortunately, the U.S. Supreme Court made it a heck of a lot harder with the McCutchen case, which is that U.S. Supreme Court case that a lot of the ARISA plans put into their letters these days. But, that case, the irony of it all is that in that particular case, the plan, and nobody had even reviewed it before it got to the Supreme Court, the plan itself didn't have proper subro language. So when the case got remanded, basically there was no lien. But basically what the Supreme Court said is, in a nutshell, these plans can write whatever they want. And as long as they put it into their plan, that's, what you're stuck with. So really the critical thing ultimately with ARISA is making the request that you were talking about, which is a 1024B4 request, get all the plan docs, see what that plan says, and determine the strength or lack of strength of their rights based on the plan language. Really the linchpin here is attacking on multiple fronts, making sure that you get that letter out, triggers penalties if they don't respond, but you got to ask the plan itself. You can't send it to Rawlings or Equian or Optum or any of these third-party recovery vendors. You got to send it to the plan itself. They don't want to disclose a lot of the stuff, so sometimes they don't respond, and that then gives you some leverage with penalties. And ultimately, if it disavows made whole and common fund and has airtight language, it's going to be an uphill fight to try and get a reduction, but it's still possible. Our lien resolution group averages almost 50% reductions on these plans, even in spite of the bad law that's out there. So it's possible. You just have to know the right buttons to push. And so all the people that are part of our team are people that came from the other side, that work for these recovery contractors, so they know those tricks of the trade, which is something that frankly most lawyers and law firms are at a disadvantage, because they don't have that insider knowledge and insight to be able to navigate these issues and really push hard on the plans to get the reduction.
Yeah. So how can these qualified settlement funds expedite resolution of catastrophic and complicated cases?
QSFs, qualified settlement funds, really are something that are underutilized. They're very common in the mass tort area where defendant settles with thousands of plaintiffs, dumps a bunch of money into one of these funds, and then the fund settles out with each individual claimant. But they can be used in any personal injury recovery because that's the way the regulations are written that govern these things. But basically, it's a temporary trust that can be created as a receptacle for settlement funds. And where they really come in handy are cases where perhaps you've got multiple defendants and you may settle out with one of the underlying coverages, but there's going to be a lot more down the line. You can aggregate all the coverage together and then make a decision on what to do. If you've got some of these difficult lien resolution issues, if you've got Medicare compliance issues, if you've got government benefit preservation issues, or the client might be interested in a structured settlement, or the lawyers trying to defer taxes on their fees with attorney fee structures or other attorney fee deferral options, setting one of these up, it gets the defendant out of the mix. Basically, you settle with the defendant for cash. They just make a payment into the QSF, and then all these sorts of issues can be dealt with, and then the trust is dissolved once all the funds are dispersed. And it allows the lawyers to get paid quickly to, if the client's money needs to be held for a period of time while planning is being done, that can be done. So one of the cases I recently used this on was a minor catastrophic case where there were a bunch of lien resolution issues. So I still have a law practice that is separate from Synergy, where I do Medicaid lien reduction work here in Florida, because here in Florida, you got to fight every Medicaid lien through a administrative law process. Anyway, we were going through that. There were other liens, there were government benefits at issue, and it was, a pretty large catastrophic settlement. So the QSF allowed the lawyer settle the case quickly and just breathing room and time to deal with all these different issues. And it just led to a much better outcome ultimately for the client and for the lawyer. It's just another tool that you can use in the right situation. It just depends, every case is different, but there are some really good uses for that type of device.
So I got a question. You might not know the answer. You might. Either way, it's not going to be bad. I won't hold it against you either way. How about that?
Sounds good.
So, I've done some of these, I've structured some of my fees back when I was younger. And I still hadn't started getting them yet. I wanted to start getting them when I'm 65, and I'm 64 and a half. So I'm looking forward to that. But the deal is, and I was always, what all these people would tell me is, you can't cash the check. I mean, if you get the check, the checks, you can never see your fee. The fee's got to go directly into it. But is that still the same when you got this QSF, or can you throw all the money in the QSF and then say, I ain't decided, I got a $3 million fee or $1 million fee, and maybe I want to structure half of it. Maybe I need the other half, to pay taxes and stuff like that, or go to board or whatever. Will that qualify or not?
Yeah, so that's the beauty of it. It lets you do that. And that's why a lot of them that we do are specifically just for attorney fee deferrals, because the lawyer wants some time to make a decision, doesn't want the fees to immediately come into his law firm, because once you do that, then you can't do this. But if it goes into the QSF is basically like the money almost still being in the defendant's hand. So that's
like an escrow.
Yeah. But it steps into the shoes of the defendant. So what that allows is all these options to still be on the table. It doesn't trigger constructive receipt. So constructive receipt is what would destroy the ability to do any type of fee deferral. So that's the beauty of this.
So does a special needs trust ever come into play with anything that you do, or is that a whole nother deal? Because this is not my expertise. I'll be honest with you.
Yeah, I mean that's something I deal with almost daily. Actually, just earlier today did a client consult on that, and it really is an issue that arises only in the context of Medicaid or SSI or both. Those are needs-based benefits. If it's disability related, generally Medicaid will have a $2,000 asset cap if you're single, $3,000 if you're married. Those are the SSI minimum as well. So, even a relatively small settlement can trigger a large problem for an injury victim if they get these government benefits. So special needs trusts are a staple because it's a way of taking a personal injury settlement and putting it into something that renders it not countable. And so $10 million in a special needs trust and the client can still get Medicaid, which we all know a lot of these catastrophic cases, you might get a $5 million recovery, which sounds great, but the life care plan is $50 million, $75 million, $100 million. The money that they get is not enough. They're gonna need government benefits. So the special needs trust allows them to settle that case, continue to get their benefits, but have a large supplemental fund that can pay for all the things that Medicaid doesn't pay for, because Medicaid, unfortunately, is the minimum. And so it's not always the greatest, at least with a special needs trust to augment what Medicaid is providing. The standard of care for that injury victim is raised, and it gives them, the injury victim's family, a framework to manage that person's life, the financial, but also the level of care. A special needs trust can hire care managers and help provide a support system for the injury victim and the family, so that the family is not left with, how do we manage the money? How do we make sure we don't lose eligibility? How do we get the right care? How do we get the durable medical equipment we need? All those things are things that special needs trust can do. So it's so important for injury victims to get that kind of advice, so they know what to do when they resolve a case if they're on those government benefits.
So tell me about your book. I know you told me that all the proceeds go to a charity. I don't know which charity, but it's called The Art of the Settlement. How can people get it? And tell me about what they will gain from reading it. What's your takeaways from this book?
Well, an important point is only trial lawyers are going to want to read this. Everybody else probably would be put to sleep, and even trial lawyers may struggle. It's a bit dense. It is more of a technical guide for trial lawyers to deal with basically all the stuff I've been talking about today. It allows them to issue, spot, make sure they understand, QSFs, when to use them, why to use them, special needs trust, Medicare compliance, ARISA lien basics, a lot of information on Medicare compliance. I think there's 4 or 5 chapters, because shoot, you could write a whole book just on that topic alone, but also on these ethical duties and responsibilities and malpractice risks. All that stuff is really covered in it. It's available on Amazon. The charity that the money is going to is a local charity here in Orlando called the Fain House. Jeff Fain is former NFL football player and was adopted, and he created a place for kids that age out of the foster system to be mentored and hopefully go on to have a successful life, because the statistics aren't great for those that age out of the foster system without the type of mentoring and intervention that they do. So very proud to be associated with that, and was really, for me, I wrote the book because I wanted to help lawyers better understand these issues and be better prepared to issue, spot, and make sure they get experts, on board, so that client is protected. I didn't write it for my own financial gain, so I wanted to donate anything that was made.
The art of the settlement, Art of Settlement by Jason Lazarus. And so you'll be, not only 2 things you'll be doing out there. Number 1, you'll be helping a worthy cause, and number 2, you might be protecting yourself from getting sued one day. And you owe a ethical duty to your client to at least know enough to know what questions to ask. It's like I say, you ain't got to be an expert on this, but you need to know enough to know what to ask. And if anything that I didn't cover, Jason, that you think, because like I said, I know management, and I know marketing, but I do not know this. I'm not going to lie about it. I used to hire companies when I was getting into stuff like this because I was scared to death of it. But I was. I mean, you know, there's one lawsuit I never want to deal with, and that's one of the USA versus Ken Hardison. I always said I don't want that. That's one lawsuit I don't want to be involved in.
Amen.
You know, they got too much power. So anything that we didn't cover that we should.
I think we covered the highlights. You know, we do a lot of thought leadership. So if people want to go to our website, which is synergysettlements.com, we have a blog and we have a bunch of subject matter experts. I'm certainly not the only one here. We've got some really smart and talented people that know these areas like the back of their hand. And so there's a lot of information on the website, also free webinars that we do each month for lawyers on all these subjects. So if anybody really wants to be as educated as possible, that's the best resource right there. And it covers things in tremendous detail that it would take us, you know, a couple of hours to do and bore the hell out of your guests.
Yeah. So if people want to get up with you, inquire about your services, or just pick your brain on something, how's the best way?
Yeah, so my email is jason@synergy, it's SYNERGY, settlements with an S at the end, .com. And I'll give you my cell because, you know, people reach out to me all the time. It's 407-687-4165. And we do a lot of consulting with lawyers all over the country, and we don't charge a fee to do that. I feel like that's part of our duty and obligation to help. So, you know, happy to always help when you're saddled with some of these difficult issues.
Good deal, man. Well, listen, this has been very educational for me because, you know, things change all the time, and you gotta, you know, like I say, you got a duty to your client, and I think you got a duty to yourself. And as always, when I do these, I learn something new. This QSF, I did not realize that might would have changed my life 15 years ago if I'd known that, because a couple of them that I wanted to do, but I couldn't make my mind up, and I just said, I ain't gonna do it. But if I could have put it in that'd give me more time, you know, to think it through and see how the rest, you know, see if the rest of the year is how's it going to go out on taxes and all that stuff, and do a little tax planning with it too. So, you know, you use it for a lot of different ways in retirement and tax planning. So good tips for both the lawyers and for their clients today. So thank you so much for being here, and I just really appreciate it.
My pleasure. Thanks for having me on.
All right. Until next time, this is Ken Hardison, dedicated to your success.
You have been listening to the Grow Your Law Firm podcast, the podcast that leads lawyers to more growth, profit, and freedom. Go to growyourlawfirm.com to find more ways to market and manage your law firm. Please leave us a rating and review wherever you listen to your podcasts.